she said, his word against hers.
Walzer Melcher is a family law specialist.
Need to get to that point so quickly.
No way in California to keep it secret, and it's a nuclear option. All right, welcome to Spouse Support Overview of California Law. We're just started the webinar and are letting folks join in. And you know, this has just been such an incredible experience for us. When we started putting these series of programs together, I figured there might be like 2 or 3 people watching, and I just love doing this stuff. And it's turned out to be so great. And we have over 100 folks on this program, you know, a lot of friends and people I know and been in touch with. We have Al Keep, we have Ann Murphy, Art Grader, who's been in here several times and given me some great advice. You know, Don Gray, who, you know, I look up to and is just an incredible author. And when I have complex issues, I look at her book. And just like I say, just going through the list, is really, really impressed with folks that have been on here. Catherine Phillips, who I had a case with many years ago, and just happy to see her on here. Hal and Marion Stanton, Rebecca Wood, Rod, I see you there. So this is just really cool. Veronica Melamed, Tracy, Vivian. So again, just so happy that you're all on here. We are live streaming this on YouTube, and all these recordings are available on YouTube for watching later on. And so we're going to go ahead and get started. So spouse support, super important topic, obviously. And because the court has so much discretion in this area, the program that I gave a while back on transmutations was totally the opposite, where it's 4 corners of the document, no discretion. It's either a transmutation or it's not, as a matter of law. But in spouse support, the court could do almost anything. And if a judge knows how to write a decision, it's not going to be attacked on appeal or changed on appeal. So we really, really need to win this thing for our client, or get the best outcome for our client at the trial level, and understand the depth of the court's discretion. Certainly it's bounded by some case law and factors that we're going to go through, but the court has massive power in this area. And the thing that's good about it is that it allows us to be creative if we know the rules. So this is me, Walzer Melcher. Like I mentioned, on YouTube, we're putting all this stuff up there. And over time, as we keep doing this, we're just going to have a great library to have these resources. So if you ever wanted to go back, look at it later or share it. I'm also seeing this as forming almost like a study group where we're coming in here and sharing ideas. I'm hoping to have some co-presenters coming up from outside the office, and you know, and really helping to share these ideas, learn from each other. That's what it's all about. I've been really active on LinkedIn. I like this a lot, and I recommend it for all of you that aren't on there already. It's just a great way to renew contacts and meet lawyers all over the world. So I'm hoping that if we're not already connected on LinkedIn, that you would go ahead and search for me and connect up with me there.
So why do we care about spousal support? Interestingly enough, spousal support could be the largest financial issue that you have in a case. And in fact, it could be much larger than the property that's actually being divided. Take, for example, if you have a $2 million estate that's getting divided, but you have a marriage of long duration, you have $10,000 to $20,000 monthly spousal support order that could go on indefinitely, that could easily surpass the property that's at issue. For those of you who don't know me, I'm Kristina Hohne. I'm a partner here at Walzer Melcher. You can also connect with me on LinkedIn. Before joining the firm, I actually practiced civil litigation. I did mostly business and commercial lit, some employment defense, products liability defense, and a little bit of probate. I find that the civil background is actually instrumental in helping, you know, inform the way we look at and analyze issues, particularly the discovery arena. So let's jump right in to the topics we're going to discuss today. And this is sort of meant to be an agenda. So we're going to really tackle 4 main issues today. Income available for support. What is it? and how is it defined? And we're going to spend a lot of time on this topic because, as Chris and I are going to show you, it's really not, a defined term set in stone. We're going to discuss temporary versus permanent support. When do we use them, and what are the differences between them? Security. I know you might be thinking that's an interesting topic to have for spousal support, but believe it or not, there is precedent to have security for spousal support orders. What is it, and when can it be ordered? So we'll go through that. And then we'll end the day with modifications. Is it appropriate to modify in your case? Is it worth it to bring? And I think that's a particularly timely topic in light of COVID, with people being laid off and furloughed. So with that, let's jump right into the first topic. Income available for support. Now you'll notice, Chris, on the side, we have this acronym, IAF-SS, and we often hear of income available for support, IAFS. But as we're going to go through, it's actually much different for child support and spousal support. So we're going to try out this little moniker, IAF-SS, and when we refer to it, that's what we're talking about. So we really have to start with, what is the purpose of income available for support? Well, we are really looking at historical data to figure out what a order should be going on in the future. So we need to assess what each party is reasonably expected to receive in income and benefits in the future. But you might be wondering, the tax code has definitions of income, so isn't that enough? Shouldn't that be enough? And oddly enough, for spousal support, it's really only the starting point. The court is not bound by technical definitions of income.
So that's an important thing to keep in mind as you're doing research and you're looking at income cases. Pay attention, obviously, whether that's a child support one or a spouse support one. For child support, we have a well-defined definition of income that follows generally the tax code in Family Code 4058. And so that is this whole world of its own. And when we're dealing with child support and using the guideline, we need to use the guideline definition of income. Spouse support, though, has no definition of income. There's nowhere in 4320 or there are other sections that define what income they're talking about. So that, and there's case law like Blazer that says specifically the definition of income for child support purposes is not the definition of income for spouse support. And there's reasons, policy reasons, why we don't mix those two. Spouse support has some certainly weighty policies behind it, but nothing like child support from Family Code 4053, which is just an incredible section if you're ever litigating over child support, where it states all the policy reasons behind the guideline. And I think maybe one of the first ones in there, it says is that the child support is the top priority of the state of California. So that's pretty intense. We don't have any language like that in 4320. I kind of think it's the opposite, where it says in 4320, the court shall consider these factors, but once the court's considered them, you can do almost whatever you want compared to child support. So I think that's a difference there in policy, why we're not going to mix definitions.
So let's take an example when we're talking about discretion. Say you have, for example, somebody who owns some properties and they have loans on the property. You have principal payments that need to be made on the property for those loans. Should that reduce the income available for support? Well, we actually have a case right on point that was decided earlier this year. Husband tried to argue that the principal payments he made on some separate property, commercial property, should reduce the income available for support. And the trial court said no, it shouldn't. But consequently, because of that, the trial court ended up ordering a monthly spousal support order that was higher than the income that he had left to support his children. So he appealed. Authority on point. So the family court looked to outside authority and relied on a case in Wyoming, thought that was a reasonable standard. And really, it depends. It depends whether we're going to take these into consideration. And as long as the payments are reasonably and legitimately reduce his income, then the court can consider it. And you can see all sorts of reasons behind that. You can see somebody who maybe gets a loan post-separation to try to divert the income that way to reduce their income available for support. But you can also understand that you have loans in place that need to be paid. Otherwise, those income producing assets are going to be placed into foreclosure. So, this important idea in DeLuca is really, it depends, and it's something for the court to consider. And this is an interesting point because, from a tax perspective, you really can't write off those principal payments. And you would be, so you look at it from one perspective, the income is not there, but from the other, you're purchasing the acquisition of an asset and you're trying to increase your net worth.
And so I think DeLuca looks at it as an income framework, but it's also a property issue and an obligation issue. And under 4320, the court does have to consider obligations of a party. And so there was the obligation under this loan to make these payments. So even if we didn't look at it in an income context, you could look at it as an obligation context. Now, depreciation is something we've dealt with in many cases. And basically what we have going on here is a tax deduction that assumes that this asset that we're using for business purposes will eventually have to be replaced, and the IRS allows us to write off the value of that asset as it's being used up over its useful lifetime, or in some cases all accelerated in the first year of acquisition. We may be able to take a big depreciation deduction under IRC 179. And the key here is that that deduction can be taken even if the property isn't replaced. The classic example of that is with apartment buildings, where these ones may be 50 years old and have never been replaced. The depreciation doesn't apply to the land, but it applies to the building. And go around LA, all these ugly apartment buildings were made in the 50s. They're still there. They have not been replaced. But over whatever it is, 39 years or whatever, that's been completely depreciated. And so that owner got a tax benefit on the assumption that they were going to replace the building after, I'm assuming, 39 years, but they never did. So, there's an argument to be made to add it back or ignore it when we're calculating somebody's income available for support. And the argument that I would have is like, well, what kind of capital asset here are we depreciating? Is there really going to be a plan to replace it? If it were a computer system, I would say absolutely, because we know our computers for work don't last that long, and we're absolutely going to replace those things. So I would think, of course, if you had some really expensive server that you bought, that you should be able to depreciate that and take that against income, because we know in a period of years that we're going to have to buy another one. So that seems legitimate to me. Some people have added that back as non-taxable income, which is super, super harsh. And so basically there's almost a double penalty there. So we're not only adding it back, but we're doing it as treating it as non-taxable income. I don't really like that so much, but there's a lot of argument here. I think that the point is don't just say, hey, depreciation, we're adding it back, or depreciation is good. You want to say, well, what is that equipment? Is there a history of it being replaced? Why is it going to need to actually be replaced? Is it wearing out? I would go into the facts of that and show that it's just not some tax benefit. Now, we have this new case, Hohne, that is pretty amazing, and it's a child support case. So it doesn't apply here for spouse support purposes, but certainly does for child. And Hohne builds on ASFA. So ASFA is an older case that said in that real estate apartment building example that you can't take the depreciation deduction against income when you're calculating that payor's child support. That depreciation is added back for setting child support. Hohne goes one step further and says any depreciation for even a business equipment would be added back unless they show it's required for the operation of the business. And the reason why that language is in there, because that's part of the definition of income in the guideline, that these deductions are available to be taken against a payor's income if they're required for the operation of the business. So that makes sense. But the thing that's amazing about Hohne is it says that this low presumption of correctness of tax returns signed under penalty of perjury is dicta, and they didn't apply the low presumption. And I don't know, I haven't studied it to see if it's really was dicta or not, but gee, we all been using that low production for presumption for a long time. So that's an amazing footnote. You know, if you want to know about these cases, Don Gray is sending out these case summaries and case alerts regularly. You know, we can't even see the case as quick as she gets them out. So if you're not on her mailing list or listserv, you should get that, because that's how I'm keeping touch and all this stuff. Now, like I say, you don't have to worry about, for our purposes, spousal support, because Blazer says these child support cases don't apply to spousal support. But certainly in a child support case, we got to grapple with Hohne.
So let's talk about income averaging. What is it? Why do we do it? Well, you know, like most people, income fluctuates. So we want to take an average of people's income over a set period of time. But as you can already guess, this is where a lot of games will get played, because it can vary between what period you use, what type of measure you use to average them. The most important thing, though, is to make sure that you're not cherry picking data that best supports your case if it doesn't come out credible. You need to use a reasonably illustrative period and be able to defend it. As we'll get into a case later on in the presentation, you'll see exactly the pitfall that can befall you if you don't. So there are different types of statistical ways you can average numbers. We'll go through them. Don't get scared. I know I'm taking you back to junior high mathematics, but we'll go through them, we'll define them, and we'll give you examples of each. But it's important to note, those are legitimate statistical ways to develop an average. So keep them in mind when you are developing your theories.
So in this example, we're going to run through all those different ways of averaging income using the same data. So here in this chart, we have the 7 years of annual income. Last year, this person made $800,000 in 1 year, but back in 2013, it was only $100,000. So let's just assume that that's our data. That's what's available to work with. And we're now going to go through using this data and applying those different ways of averaging income that are all, like Kristina mentioned, legitimate statistical, mathematical methods, and seeing how the numbers come out, because you may want to use some of these for yourself. Now, the first is mean. Now, this is what we use commonly. It's a simple average. So we don't call it, oh, what's the mean? But what we're talking about is a simple average where we add up those 7 numbers and we divide by 7. So I've listed the 7 numbers there. I've divided it by 7. And the simple average or mean is $414,000 if we were going to use that approach.
The next one we'll talk about is median. This is where you list the values in numerical order, and the middle one is the median. So out of this data that Chris has just talked about, we have the 7 numbers right there from top to bottom, and you can see that 300,000 is right in the middle. That would be the median. Now, if you have an even set of numbers, let me save you the Google search, you just average the middle 2 numbers. The next one we'll talk about is mode. And this is the value that appears the most in a set of data. So again, using our data, you can see from top to bottom, the number 200,000 appears twice. All the other numbers appear just once. So in our data, the mode is 200,000. Now, depending on the type of data you have, you might have multiple modes, or you could have no mode at all.
Now, range is an interesting one. We're saying, what is the difference between the highest number and the lowest number? So here we had the high of $800,000 last year of income compared to the low of $100,000 in the year 2013. And we just take $800,000 minus $100,000, come up with $700,000, and there's the range. And just the way that these numbers worked out, it just weighted so heavily towards the last year. But, you know, that's, again, another way of doing it. I don't see people doing it often, but it is a way. What mostly we do with a forensic accountant would be to do a weighted average. And I put this chart here because the weighted average is very, very simple. And I think it's kind of mysterious to some some of us, but it's so, so simple and it's pretty powerful. But there's also games that could be played here. And with a weighted average, what we're doing is just placing emphasis on one number or a group of numbers compared to others. Remember, in that simple average, if you look at this column on the left, we just took all those numbers from 100 to $800,000 and we added them together. It's a group of 7 numbers, and we divided by 7, we came up with 414,000. In a weighted average, we would say, well, there's some numbers that we think are more representative, that are more relevant to the inquiry, and we're going to put special weight on those. And so in this example, the forensic thinks that last year's income is a lot more representative than any other years. As a matter of fact, it is the trend, or it's going to be repeated. And so how do we mathematically figure that out or describe that? Well, it's through this weighting. So here we put a weight of 1, which is just neutral on all these numbers except for last year, which we triple weighted. So it's a weight of 3. And then for each row, we take the number, we multiply it times the weight, and we come up with a product, and we add them up together. Now, since these are all weighted 1, it all comes out exactly the same as the underlying number. But with a triple weight on $800,000, that turns into $2,400,000. So now we add all those products together, and then what we do is add the weighting together. So we have a total of 9 weights. And so now we just divide the product by the weight, and we come up with 500,000. So I hope this helps, because we see this a lot in income available reports. We also see it for valuation reports, where we're trying to understand when we're capitalizing income of a business to determine its value, what number we want to look at. And we often use the weighted average.
So what does this all mean? We just went through these 5 different scenarios, and they were all based on the same statistical data, but you can see right here how the average came out very differently, all the way from 200,000 to 700,000, depending on how you do it. So again, this is a place where we can be creative, where we can play some games if we want, but it's also a trap if you're doing something that you can't defend. And we saw that. Oh, sorry.
Yeah, and I would, sorry to jump in on there. Definitely, I would be looking at just re-weighting things, and if you're cross-examining the forensic and saying, well, hey, if you had put a different weight on this, and we thought that 2018 was more representative, and you triple weighted that, how would it come out? And now that you can see that table, you can do it on your own.
So marriage of riddle, and I think this is a cautionary tale for us all. In this case, the wife's accountant was criticized for cherry picking information she used to average the husband's income available for child support and spousal support. So let's take a look at the facts of this case. Here we had the husband was a commissioned salesperson. So we already know right there that we're going to have fluctuating income. And by the way, this was for temporary spousal and child support. Now, if you took his income over the last 12 months and divided it by 12 to come up with a monthly number, it was $8,394. But if you just took the last 2 months, it was $21,950. You can see that's nearly 3 times the 12-month average. And this is exactly what wife's accountant did. Wife's accountant used the last 2 months, and surprisingly, it's what the trial court agreed with to set child support and spousal support. Now, before we go and vilify the wife's accountant, I read the facts, and I was trying to understand, why would you use this 2-month average? Well, the hearing was set for the end of February of the year in which the order was made. So the accountant used January and February data for that year. So year-to-date data. However, the court notes that in February, husband had a huge commission. So you can see that the data would be skewed just based on that. And unsurprisingly, the Court of Appeal reversed.
Yeah, so it's a great case, and I love how the cases have these names like riddle, and that show this is a riddle that wasn't too complicated to resolve, but it's a cool case to read because they use statistical analysis in there. When you read Riddle, the justice who wrote that knew a lot about statistics because the language comes almost like out of a textbook. And what they're talking about is sampling. We're taking data, we're sampling it, and then coming up with conclusions on it. Well, that sample has to be representative. So the 2 months, and I didn't realize that factoid there, Kristina, that was cool, but the 2 months of that year were not representative of what we were trying to figure out, which is reliably going forward, how much can this salesperson make so that we can set support on that number, not just cherry picking a number. So the trial court used an unjustifiable sample and said the mere 2 months was an embarrassingly short period to predict annual income. And that's where I come from on this is it's a prediction. We're using past results to predict future performance. And if we're cherry picking, we're not doing it right. Also in Riddle, I believe this was the case where they criticized this use of the word cash flow. And I still see this in forensic accounting reports all the time. It drives me nuts, but we're not setting support on cash flow, we're setting support on income. Cash flow is a completely different concept. And I know that's been in our terminology. Oh, it's cash flow for support. We're not doing cash flow. And so Riddle, I believe, says it's a sloppy synonym for income. So that's why is income available for support.
Okay, so now we're going to jump into our second topic of the day, temporary versus permanent support. So temporary support, I love this graphic here, the Band-Aid up top. So what is the purpose of temporary support? It's supposed to get us from the beginning of the case to the end of the case before a permanent order can be made. It is meant to preserve status quo. You know, there is a guideline that's often used, and you can see right here, the Santa Clara formula, 40% of payer's income after child support paid, less 50% of payee's income, excluding the amount of income allocated to child support. That's super important. And I know Chris will elaborate a little bit more on that in a couple of minutes, but I mean, why do we do it like this? We look at, you know, mostly need and ability to pay because there's really not enough time to go through the whole 4320 factors at an RFO hearing. And so the formula can be blunt, but brutal.
And so this Santa Clara formula that we use in Los Angeles I like to be able to do this in my head. And now that we don't have the tax deductibility of alimony going forward, it's pretty easy to do. So when clients like, well, hey, how much could I have to pay in temporary spouse support? It's like, well, you know, if your spouse doesn't make any money, it's going to be 40% of your after-tax income. And if your spouse makes some money, then it'll be 40% of your after-tax income less 50% of his or her after-tax income. And so we could figure that in our head pretty quick. Now, the child support one, I was informed by Art Grader, who is the hands down expert on DissoMaster. So if you ever have any questions on how to use DissoMaster, what all this stuff means, the inner workings of it, you need to talk to Art because he knows this stuff inside and out. And he was kind enough to send me an email when he saw the slides about how this works. Because in my mind, I had always, when I was calculating this, said, oh, well, if there's child support, we take that support payment off the top. So if somebody's making, you know, I'm just making up a number, $50,000 a month, and they're paying $10,000 in child support, we would say, well, their income is available for spouse support, it's only $40,000. But Art pointed out that actually under that guideline is that we're looking at the relative share of income of the payor that's being allocated to the child support calculation. So it doesn't come out exactly as just knocking off the child support amount, but you could still get there fairly close in your head if you look at that formula. And then other counties, courts have different formulas, but this is the one I'm most familiar with. So the main thing is that these are just suggestions. And so in child support, and I wish they would get rid of this name, the guideline, the child support guideline, that is not a guideline. It's a mandate. courts shall use the child support formula for setting support. It's presumptively correct, and it's very difficult to get around it. So that's not a guideline, it's a mandate. Temporary spouse support is more like a guideline. It's a suggestion, it's a rule of thumb, it's something you can do, you can consider, but you're not bound by. And so these are not law imposed. So Berlini is a great case because it reminds us that circumstances may justify deviating or not using that guideline for temporary spouse support. And they've gone through some factors there, like the tax consequences, support paid for other relationships, unusually high housing, special needs, health, other expenses, obligations that make the use of the guideline inappropriate. I would throw in there maybe no housing expenses. This is something that I've seen in some cases where people are fortunate enough not to have a mortgage. And so they don't pay rent and they don't pay a mortgage. Well, to me, whether it's spousal or child support, our biggest expense for most folks is housing. And if you don't have a housing expense, then you don't have much of a need for support. And conversely, if you don't have a housing expense, you have a greater ability to contribute towards support. So I would be looking at that and arguing Berlini rather than just blindly entering in income and spitting it out as a support order.
Now let's talk about permanent spousal support. So here the court has wide discretion, but the court must consider the 4320 factors along with the marital standard of living. And when we look at those factors, they mostly relate to the financial need of the supported party and the ability to pay of the supporting party. The court also looks at, asset distribution. What is each party receiving? What does each party have? And there are a lot of policy considerations at play. Age of the parties, the length of marriage, if there's any DV or documented history of abuse. So, when you're looking at your case and cases, you have to consider what that number should be. And when you look at the cases, the court has wide discretion to do that.
And one thing on here, and we're not going to have time to run through all the 4320 factors because this is, again, just an overview, but it's that last factor, I think it's K, any other just and equitable factor. So, all these things, these cases don't fit into boxes that easily. So if you just feel like, hey, something just doesn't feel right to me and about this just seems way harsh, argue the other just and equitable factor. We got in a question from Anna Howard about, there's a retired parties, there's no spouse support. Can we use pension mandatory distributions from the IRA, Social Security, all this stuff? I think again, there's a difference between child support definition and spouse support definition. If somebody's getting mandatory distributions from a retirement account or Social Security, I think it has to be considered under 4320. Now the court may say, look, that is a mandatory distribution that has to come out because they're over 70 and a half. And so it's not really voluntary, it's mandatory, and it's really just converting an asset that they have in the form of a retirement account now into some stream of taxable income. Maybe it should be ignored. But, hey, that's all can go into the mix.
That's a really important point, Chris, about how the court can fashion orders that are just and reasonable under the circumstances. But we need to keep in mind that the court, while it has wide discretion, that discretion is not limitless. And we saw that in a case that came out last year, marriage of Ciprari. I erroneously had been calling it Ciprari, but I learned during one of Don Gray's webinars that it's Ciprari with a hard C, like a CH. But here, and this was a local court judge, we look at this case and we mostly think about the tracing issues that were involved, but there was actually a spousal support order there too. And the court set a $5,000 per month permanent spousal support order, even though the husband had substantial incomes and the parties enjoyed what the court found was an upper class lifestyle. And if you look at the facts of that case, husband actually earned or was noted to have about 2.5 times the income of the wife. And so basically, I don't know that the $5,000 number would have been disturbed on appeal if the trial court had explained how it came up with that number, somehow tied it into the marital standard of living, and explained the reasoning for that.
That's one thing to think about if you're considering appealing, and it's a Pyrrhic victory where maybe the courts of appeal says, hey, you know what, I don't like this spouse support order because I can't figure out how the trial court arrived at it. And so it has to be remanded. And we think, wow, we won, we got it reversed and remanded. Well, on remand, this judge can just articulate better. And then if there was another appeal, it would probably be lost. There's a similar in my YR versus AF case, which was an appeal of a deviation from child support guideline. When I was arguing that case, the Court of Appeals said, we don't have a problem necessarily with the amount of support that was ordered. We just have a problem whether the court made the required findings to get there and remanded it. So, you know, we can win and go through that whole process and then get back down to the trial court level. And then the trial court may be able to make exactly the dollar for dollar, the same order, just articulating it differently. And then the Court of Appeal would give it the thumbs up. Now, one thing to point out here, and this is another appeal of mine called Grimes and Moo, and I'm not sure I'm pronouncing that right, so don't quote me on that. But in Grimes, it's a spouse support. There's a spouse support issue in there, and what happened at the trial court level is that the wife had not made adequate efforts to be fully employed. She went back to work, but she wasn't working to the court's satisfaction, and after being warned, and so didn't have as much income as the trial court thought that she should. And when they got to trial and they set permanent spouse support, the trial court noted that Mr. Grimes had paid a lot of temporary support based on the lower income that wife was making, and that had she made better efforts to increase her income, his support would have been lower. And the court considered that circumstance in setting the duration and amount of permanent spouse support, and it was even in a long-term marriage. And so that's a very small part of the case that's buried in there at that page 426. But I think, again, that goes into other just and equitable factors and shows the power of the court. So if you see something happening where there's very, very long temporary support period, maybe somebody paid excess support, because of a failure to make reasonable efforts issue, argue that in permanent support and saying like, hey, my client should get a break here. And so in the opposite, say if there was a lower level of support paid than should have been paid, temporary support was set at X, but it should have been 2X had we known the facts back then. And so this payor got away with paying less than his or her fair share. Argue that for permanent support, cite Grimes and saying, hey, judge, you can consider that's just and equitable to increase the duration or amount of permanent support based on what happened at the temporary level. Oh, yeah. So one thing here, I know it's forbidden to use DissoMaster or any other child spouse support calculator to set permanent spouse support. I know I'm not even going to attempt to pronounce that name, but it's there. So we know we can't do that. I acknowledge we can't do that, but I still use the program not to calculate support, but to calculate taxes. And so what I'll do is I'll block spouse support, I'll enter in the incomes, and if we have some child support, throw that in there too. And then we can see on the cash flow section on the right side of the screen what they have left over to play with for spouse support. And so the way I view DissoMaster is just like a tax calculator. So I'm not using it to run it. I'm not using it to calculate spouse support, but I'm using it to calculate what they have left over. And so after paying taxes and maybe child support. So I like to do that. So then I can say concrete, hey, judge, after paying taxes, this person's tax rate, blah, 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 this is what we have left over. But certainly with the caution, like we're not using it to calculate permanent spouse support so they don't get angry at you.
Okay, jumping into our third topic, security. And I'm wondering if your mind is going to be blown as much as mine was when I first learned about this topic. And that is, can you have security for spousal support orders? You know, it makes sense to have them for child support orders because there is a defined term for how long child support orders are supposed to be made. But for spousal support, I mean, if it terminates upon death, why would you have security for an award to secure an event in which the support order terminates? Well, according to the law, you know, there are a couple of family code sections there that I encourage you to check out. Trial court has discretion to require such security. And, you know, I'm sure we could come up with a whole host of factors when it should be considered, why it should be considered, and you'll want to do that in certain cases. And I think it just does depend on the facts. You'll also want to think about how detailed do you want to be in your judgment? How much should the security be? Do you want to have, you know, step downs depending on the amount of years? And here's where you have to think about a spousal support order that's for a finite period of time, let's say 10 years, versus one that can go on indefinitely. A cool code section that I also recommend that you check out is Family Code Section 2051. And anytime you do have security in your judgment, either party can notify the insurance carrier of this obligation. So that way, if there is a change of beneficiaries, if there's a cancellation of the policy, if the policy lapses, you can request that the insurance company give you notice of that. Now, don't get too excited because it's not, you know, it's not an injunction. It's not like the ATROs. Nobody's prohibited from doing that, but at least you will become aware of it in case it happens so that you can determine how it impacts your case and how you want to proceed, if at all.
I love that code section. So we utilize that when we're representing the supported spouse to make sure that there's this policy is going to be there, because obviously it would be pretty bad if that security wasn't in place and there was a death, there's no benefit. And sure, a claim could be made after the deceased spouse's estate, but if they died without enough money in the estate, our client doesn't get anything. So I encourage taking a look at that code section. Now, the amount of security is something that's been kind of a mystery to courts and to us. It's like, well, why is it $250,000, $500,000, $1 million in life insurance? Where do these numbers come from? What I would do is be looking at it actuarially. Well, how much is the support? How long is the potential duration? We would be looking at life expectancy if it's an indefinite support order following a long-term marriage. And we can figure out actuarially, like, this is how much is going to be paid over the time, and this is what's necessary to secure it. What is the availability of insurance based on the health of the payor and the cost of that insurance? All those things can go in there to say what's appropriate. What I think is that people have a right. They're going to get remarried. They're going to get in different relationships. They want to protect their kids. So do we want to use up all their available life insurance just to secure this spouse support? Or do we want to say, well, it's only going to be a portion of what's available to secure spouse support, and the rest can be used to provide a benefit to the children or new mate of this party? So we're going to take a look at it. And as Kristina alluded to, if you have a fixed duration spouse support, that's the easiest. So if it's 10 years of support and it terminates, then we want, and I'm just going to make up a number for easy math, $1 million in life insurance. We can just write into the judgment, well, hey, every year, 10% of that requirement reduces. So at year 5, it's only 50% of $1 million. In year 9, it's only 10% of $1 million or $100,000 in coverage, because we need the $1 million at year 1. We don't need $1 million at year 9 when we only have 1 year left of support to be paid. So I would encourage you to kind of take a look at that. It really only works well when you have a fixed term support, but it can sure help.
Chris, let me ask you a follow-up practical question. So if you were going to have security in your support order, how detailed would you be in terms of all the actuarial numbers and compiling that data?
Well, I think the actuarial part is going to be in the negotiation. In the actual agreement itself, I want to know who's the owner of the policy. And that's a huge issue because we figure support's going to terminate or modify, and the policy should be owned or go back to the payor of support, I think, because otherwise we could wind up with a perverse situation where there's no support order anymore, but now we have an ex-spouse who's the owner of a policy on our client. That's what the Valley fight was about, actually. It wasn't a big number. And out of all the issues in Valley, which was a gigantic case, the one that went up that we fought and went all the way up to the California Supreme Court was over who was going to own this policy, probably more than anything else.
Okay, so let's jump right into our fourth and final topic, modification. So the first thing to note is the change of circumstances rule. Now, for somebody like me with a civil background, I find this to be fascinating because you think about how do we get, once an issue is finalized and a final order is made, there are only, a couple procedural ways that you can go back and try to attack that order. We've got res judicata and collateral estoppel to deal with. You can move to set it aside. You can ask for a new trial. You can ask for motion for reconsideration. You can appeal. I'm sure I'm missing a couple there. But we need to balance that with this idea that spousal support needs to be flexible. Why? Because as we've been talking about this whole webinar, we are looking at past data to predict the future, but it's not always an accurate picture. So we need to make sure that these orders are flexible enough that we can modify in the future upward or downward as the circumstances may exist. So you'll hear this magic language, the change of circumstances rule. And it's really important. I think a lot of people forget it is a jurisdictional hurdle. It is something that must be cleared before the court can even consider whether a modification should be made. So if you cannot jump over this change of circumstances hurdle, you don't even get into the modification question. And Chris is going to show us a cute little graphic here on modification land.
So this to me is fundamental to our understanding is that on the left side here of this hurdle, we have the pre-RFO. We haven't filed our request and to modify support, and we want to get into a modification land. And so, but we only get to modification land, which is where the court has authority to do anything if we get over this change in circumstances hurdle. So there it is, jumping over that hurdle and off, and I just love that so much. And I'm hoping that's clear. So we need to get over that hurdle. Now we're in modification land and we're happy, and we can go to try to modify now. Now, one thing to keep in mind is that just because we're in modification land doesn't mean that it's going to be modified. Now, most likely or many times it will be, but it's not an absolute. So that change in circumstances showing is only necessary so that the court has the jurisdiction to look at whether to modify. And then once that has been shown, the court then will determine, based on the 4320 factors and other evidence, whether a modification is warranted. Now, same evidence may be used that shows the change in circumstances. Hey, my client's income went down by 80%. That's the change in circumstances. And now when I want the modification, well, why do you want it reduced? Well, my client's income went down by 80%. So it may be the same evidence, but it's introduced for two different purposes. One is jurisdictionally, and the second is factually to demonstrate the need for a modification. Now, in older case law, we thought, questioned whether we needed to show a changed circumstances to modify a temporary order. I think the weight of the modern cases say, yes, we do. We're not going to go through a hearing, set temporary support, and then the next day say, hey, I want to modify. I don't need to show anything. No, we have to have some regard or some respect for that being a final order, and not just say we're just going to modify it just continuously. So these cases say we do have to show a change. Now, how do we know that something's changed? And this has been a huge issue because the judgments and the marital settlement agreements sometimes are not good enough. And they just say support's going to be paid at X amount per month for whatever period of time, period. And then we're going into a modification and saying, well, hey, judge, I need it to go up or I need it to go down. And we're trying to jump over this changed circumstances hurdle. And the judge is like, well, how do I know what the expectations of the parties were when they entered into this agreement and what facts led them to say it was going to be $10,000 a month in spousal support? Because there's no evidence of it in the judgment or in the MSA. So now we have to go and hunt. And so the good thing about disclosures in a divorce is that at least then they would have exchanged those and there's information in there. So what I do is go get the disclosures. What was the latest I&E that was exchanged prior to making the judgment or marital settlement agreement? Say, hey, well, we can maybe make some inferences that this was at least, it was based on that data. But when we get to expectations, like, well, did somebody expect to retire at a certain time? Or that their income would go up or down or stay the same at post-judgment, we're going to have to fill that in now with testimony because it wasn't stated in the judgment or order agreement. So we'd want to put in a declaration when by our client, when we made this agreement, this is what the circumstances were. These were my expectations. This is why it's material change. So super important, just put it in there if you can get those agreed findings or the first place.
So let's talk about what I think is a very timely example. What if you have the payor spouse who is laid off, but that person receives a severance that is meant to last 1 month, 5 months, 10 months? Is that a change in circumstances? And if so, when does that change occur? Can a modification be filed while the severance is being paid or when it is expected to be paid through? For example, if you're receiving severance for 6 months, can you file that modification the day after you're laid off, or do you have to wait until the 6 months expires before you can file it? And you can see the pros and cons of each with retroactivity, but the requirement that the party continue to make the ordered amount. You can see why you would file early versus filing late. These two powerful cases, though, Marriage of Stevenson and Marriage of Sampson, you really should read them. In Stevenson, this is exactly what happened, but the severance was meant to last for 8.5 months. And so what the court decided was that there was no change in circumstance. The motion was premature and the issue was not right. And remember the jurisdictional hurdle. So they couldn't even get into modification land without first determining whether the change of circumstances existed. And this reminds me of a case that Chris and I had a few years back where husband was receiving distributions from a company. Husband said, hey, distribution stopped. That's a change of circumstances, filed his motion to modify. And so we did our due diligence, we did discovery, and it turned out it was true. The distributions had stopped. But we saw some interesting data that we couldn't quite understand. And it turned out that the company knew that these distributions were going to stop, and so decided to make a large distribution that was meant to last them through the period of time when they had stopped the distributions. And so we used Stevenson to successfully argue that that money should be allocated over a yearly, I think it was 2 years in that case, but it should be allocated over that period of time when it was supposed to last, such that there was no change of circumstances. And that is so powerful, because if you cannot jump over that jurisdictional hurdle, you can't even get to the modification question. Also keep in mind, though, just like with spousal support orders, you might appeal something, but if somebody loses their job and it's likely that they're not going to find one in the future, you have to be mindful of that too. So this is just about using your own discretion and making sure that you're filing your motions on time, but you're also making sure that you're realistic about whether or not modifications could be made once the severance expires. And again, a lot could happen in that time frame. The severance could expire, somebody could find a new job, a better job, somebody could find no job. So these are things to keep in mind.
Yeah, and it's really asking the court to allocate those lump sums, and that's the harder part. Some severances, it's like, hey, we're laying you off, we're going to pay you such and such amount per month for 1 year. Well, that's pretty clear. They're going to get a year's worth of payments. And I think if those payments are similar amounts to what the person was making previously, they have to wait the whole year. And it's after the year runs out and they're not getting any money to file for modification. If they try and go in early and basically get a reservation, you know, like, hey, this is coming. And so I just want to get my hearing set. So in month 13, I'm ready to go. Jurisdictionally, I don't think they can do that, and they have to wait till it stops for the change of circumstance to occur. And I think jurisdictionally, we're looking at the date that the RFO was filed, not the date of the hearing. So Kristina really changed the outcome of that case by using Stevenson.
I don't know about you, Chris, but this is a topic that I get asked a lot about every time there's a spousal support issue in a case. Cohabitation. What happens if the person who is receiving support is cohabitating with a new mate, a non-marital partner? Family Code Section 4323 tells us there's a rebuttable presumption of a reduced need for spousal support in that situation. Now, let's talk about presumptions, because we have rebuttable presumptions, we have conclusory presumptions, and it's really, you are trying to establish a fact, and if that fact is established, it is a legal conclusion. So in this case, all you have to establish is that the person receiving spousal support is cohabitating with a non-marital partner. In that instance, the burden then shifts on the person who's cohabitating to show a continued need for spousal support. That is huge. That is huge to make sure that you have shifted that burden. But it also makes a lot of sense that the burden shifts, because the person who is cohabitating, the person who's receiving the support, is in the better position to know how much they really need. They're the ones who know how much their non-marital partner is contributing toward the living expenses. And so what we do know is cohab can be considered a change in circumstances. That's marriage of Bauer. And while the court cannot consider new mate income, it can consider contributions that the new mate is making toward living expenses.
And like Kristina mentioned, it's a big deal for our clients. They're very upset about this when they're paying support and to a spouse or former spouse, and that person is now living with somebody else in a romantic relationship. And I think just understandably, that is upsetting. And sure, we can use 4323, but at the end of the day, the ones that I've litigated, I've never affected a change in support on it. And if you have, let me know, because I would love to hear that feedback. But it's like, I know it bothers my clients, but when you get down to it economically, it may not make a bit of difference. And only if maybe there's just massive amount of living expenses being paid by the new mate and they just have no expenses and that relationship's going to continue on, that I guess would reduce the need. But if it's just like, hey, they're living and they're sharing a little rent here or there, it may not make a big difference. Maybe you can argue it's just an equitable factor, but economically it may not make much difference. Now, retroactive modification has been a really hot topic for years. I think the dust has settled on it now pretty much, but we know that there's no jurisdiction to modify a support payment that came due prior to the filing of an RFO. So if we're here in July and we want to modify, we can file our RFO today and have the court modify any support payments that came due today or hereafter, but we can't say we want to modify the June payment. And so that's another jurisdictional limitation. And through many cases, we figured that out and it's very clear. Now, there is an exception for interim orders, or what some will call temporary orders. So that could mean you're in a hearing today and the court says, we don't have time to finish the hearing. I've heard some evidence. I've looked at the I&Es. I'm going to issue a support order of $5,000 a month. We're going to come back in 3 weeks. We're going to finish the hearing. Based on that, I'm going to make my final ruling, and we're going to go back and modify to the extent necessary the $5,000 amount that I put on this as a Band-Aid. The court can do that. But that's a very, very limited type of thing, okay? Just as a Band-Aid to finish the hearing. What we can't do, and I've seen some courts say, and I think there's even reported decisions like, sir, if I find out that you're lying about your income, I'm going to go back and modify this and assess support on the amount that you didn't include. You can't do that. I mean, there would be other penalties for it, but once that order is made, it's done. And absent an appeal or set aside or modification, that is not being changed retroactively on that threat. Now, we had some questions on whether we can agree or stipulate to confer retroactive jurisdiction, because there's sometimes where we want a final order entered on an agreement for support, but we do want to go back and tune it up because we don't have enough information. Stover says you cannot do that for child support. It is void, and you can't even use estoppel. When Stover came out, it was an unpublished decision, and I liked it, and I asked it to be published. Just sent a letter in that any of us can do, and they published it. Now, for spouse support, we may be able to do that. We don't know, but I would be very, very, very careful about retroactivity stipulations, because what could happen is that somebody double crosses us later on and says, hey, I know I signed that, but it's not valid, court, right? So be very cautious about retroactivity.
And something else you want to be cautious of is the evidence that you need for modification. So please remember that declarations are not in evidence by mere fact that they're attached to a pleading. You must actually request that they be admitted, or they could be admitted by stipulation. And so if the evidence is not received by declaration or live testimony, there's no legal basis for making a ruling. And so sometimes, and you can check out Marriage of Pasco, this case that came out, I think it was last November, for the cautionary tales that happen if you don't move your declarations into evidence. So what is the purpose of a declaration attached to an RFO? Well, the court in Pasco said it's to put you on notice as to what the person would testify about. Now, an easy fix here is just make sure that they're admitted into evidence. Make sure that the record is clear. You identify which declarations you want to move in. If you have evidentiary objections, make sure that they're subject to those and that you get a ruling from the court on those. But if, what is the good of the argument of counsel if it's based on evidence that's not before the court? It's nothing. So if you end up appealing it, you end up with no record. It can be quite costly.
So certainly that should just be in our toolbox as we make an appearance. We're on a motion RFO. Hey, Your Honor, I'm moving these declarations into evidence. Or will you receive them? Yes, they're received. Super important.
And that concludes the fourth topic that was on our agenda today.
Now, we have two more coming up. One by ACFLS that Peter Walzer and Mark Stern, who's an estate planner, are doing on death and divorce for July 29th. That's in 2 days from now. So that's going to be an awesome program. So if you're not already registered for that, you can go to our website, walzermelcher.com/seminars. You'll find the link for that. I encourage you to attend that because death and divorce is such a huge issue. Next Monday, I'm doing one with Tony Storm on privacy issues on divorce. How do we keep a public proceeding quiet when we're representing a high-profile individual or celebrity? So this is a cool program, lots of tips and tricks in that. Also free. Go to our website if you're not registered already. And hey, we've been asking for these Google reviews. Many of you have done it. I really appreciate that. Feedback is just really encouraging. And so we've sent out a link there. If you have a moment, if you can go and just give us a review, that kind of keeps us going. I'm going to be putting more of these programs on. I just got to kind of get them produced and do a little legal work in the meantime, but I want to keep doing these. I just love it a lot. So in conclusion, spouse support has a gigantic financial impact in our cases. Sometimes it's the biggest impact because the support obligation goes on so long. We don't have a finite definition for it like we do in child support for whatever the income is, but we have a lot of flexibility and a lot of case law that informs us about that. It allows us to be creative. I hope it's helpful. If you have any questions on spouse support, contact Kristina, contact me. We love to keep that conversation going, and we will see you next time.